Hi, this is Chris. And this video podcast is part one of basic considerations in drafting California legislation. There are a number of considerations in drafting legislation at the state or federal levels of government, naturally. And there are a number of items that are useful to understand before undertaking the drafting of bills and amendments here in the state of California. So before looking at some of the drafting guidelines, I think it's important to understand the format of statutes once they've been enacted and what types of legislation creates laws. So the first topic is format of codes. When the legislature passes and the governor signs or allows a bill to become law without the governor's signature, then a statute is enacted. And there are just over 155,000 statutes that are on the books in the state of California. And of course, these books, we call them codes. And they, as opposed to the federal United States codes, which are in numeric order, the codes in California are given a name rather than a number. And there are 29 of these codes, beginning with the Business and Professions Code and ending with the Welfare and Institutions Code, with, of course, 27 other codes in between. So what's the format or the organization of California statutes in these codes? Within the 29 codes, the following is the hierarchy of the provisions and how we organize the codes. We start, of course, with the 29 codes. So code is the highest. Then it goes to title, then to division, then to part, then to chapter, then to article, and then to section. So once you open up, for example, a hardbound volume of a particular code, if you're looking at the blue covered Wests or the burgundy Deerings versions of the codes, you can work your way through them until you find the specific code section. And that's where the actual law is. Next, let's look at the forms of legislative measures. So once you learn where to find the statutes, it's valuable to understand the different forms of lawmaking that occur in this state. When we use the term legislation or legislative measures, it can include bills, but also it includes resolutions, and there are three types in California, as well as proposed constitutional amendments. Now, only bills create statutes, but for example, the legislature can adopt internal rules or express its views on a federal bill or on a public policy issue by way of resolution. And of course, the legislature can place before the voters any proposed amendments to the California Constitution. So the first type of legislation, of course, is a bill, and passage is required by both the Assembly and the Senate. And a passed bill has to be presented to the governor for final action. And if it becomes law, it is a statute is the end result. The three types of resolutions are not law, but they are simply expressions from the legislature. The first two joint resolutions, which speak to the federal government, and concurrent resolutions, require passage by both the Assembly and the Senate. They are not presented to the governor. Also, a House resolution is a single House passed resolution, either by the Assembly in an HR or the Senate in an SR, and those two are not presented to the governor. And the final form of legislation is a constitutional amendment, which requires a 2/3 vote of both the Assembly and Senate. These are also not presented to the governor, and before they can be amendments to the Constitution, they have to be passed by a majority of the state's voters. Now, with each of, let's talk about the format of legislation in this state. So with each of these three types of legislation, there's a format that's followed by the attorneys in the Office of Legislative Counsel. And they, of course, are charged with drafting bills, amendments, resolutions, and constitutional amendments. The general format is they have an introduction date, a number, no matter what type of measure they are, a listing of the author or joint authors and co-authors, and then either a statement that they're an act to add, amend, or repeal sections of law, or they're relative to something for resolutions. They have a legislative council's digest, which generally explains what the law is and what the measure proposes to do, and then of course are the substantive provisions of the language. The format of bills and statutes. So just as the codes have a format or a hierarchy, so does a bill that's considered in the California legislature. We organize these substantive provisions underneath a section. So again, the section is the part of the bill that's considered the basic unit of a statute. Underneath the section, we do a subdivision, which is a small letter. Then we do a paragraph, which is a number, a numeric number. Then we do the subparagraph, which is a capital letter. Then we do a clause and a subclause after that. So what are some of the initial considerations in drafting a bill? As I mentioned at the outset, there are quite a few number of considerations to take into account when drafting bills and amendments. One of the initial questions to ask in preparation is, what's the issue or problem that's being addressed? Some commentators like to frame the question as, what's the problem to be solved by the legislation? Regardless of your approach, the purpose of the initial question is to set the stage for the bill drafter to understand what the bill author is hoping to accomplish with the bill. In other words, what's the goal or the objective of the piece of legislation? Some other questions that the bill drafter is going to pose to the author or group supporting it before the bill drafter commences drafting. To whom would the bill apply? Who might be excluded? When is it supposed to take effect? Who's responsible for enforcement? Is there a penalty for failure to comply? How does this bill interact with existing law? Are there terms that need to be defined? Are there existing definitions in current law that can be utilized? So that first step in drafting is actually understanding the problem and researching it.